A lot of you probably know. This is how the ER doctor described it or defined it. Condition which develops suddenly, often as a consequence of an identifiable injury, as opposed to something chronic which develops gradually over time. Now, what does a herniated disc mean? I want to show you on a model. The doctors are going to use this model too. I actually took it to their depositions, and I just want to illustrate this for you. So there's three sections of the spine: the cervical, the C spine, it's up here, that's the neck. Thoracic, the T spine is here, and the lumbar, the L spine is here. Now, through these vertebrae, there runs the spinal cord that comes down from the brain and the brainstem, and it's hollow in here, and the spinal cord goes down through this. So you can't see the spinal cord, but it's down in the middle. And these translucent sort of gray bands here are discs. And when you bend or manipulate your spine, the discs move and gives you flexibility. Now, the doctors describe these discs as being like a jelly donut. There's jelly in them. And when the jelly comes out, you can't get it back in. The problem is when the jelly comes, and that's called a herniation, when the jelly comes out. But when the jelly comes out, it can touch these nerves that come out the spinal cord. And it can also touch the spinal cord itself. And the evidence will show that's what happened to Mr. Bennett. Now, his area is this neck part, and he had 4 herniated discs, acute herniated discs, according to his ER records and his ER surgeon. All right, and I want to show you the lesion I talked about on Mr. Bennett's MRI of his neck 4 days after the wreck. And you'll see, 6 days after the wreck. And you see the vertebrae there, C2, C3, C4. In between C3 and C4, you see that sort of arrow-looking thing. And that band that it's coming into, that's a spinal cord. You can sort of see the margins come down, the white margins, and then you can see something's pressing against it. You see it down on the next level too. And you see on where it says damaged central cord, that's the injury, that discoloration, that white streak, that's damage to Mr. Bennett's spinal cord. And what he's got is a condition known as central cord syndrome. You're going to hear that diagnosis a lot from the doctors, but that is unanimous. He has central cord syndrome. Now, the question in this case, the big question, the key issue is what caused that bruise on the spinal cord? And according to his doctors, Dr. Chapman is the ER doctor, the ER surgeon. Dr. Bennix did 2 surgeries and follow-up. Dr. Maluna is his neurologist. They all say it was the wreck. But we still had some questions, and we like to come to court having questions answered about certain things. And 2 questions we had, just looking at it, being devil's advocate, is number 1, why didn't Lewis have immediate severe symptoms after the wreck? And the second, how hard of an impact is required to bruise that spinal cord? So, first question, why didn't Mr. Bennett have severe symptoms immediately? Because we're thinking, when there's a spinal cord injury, maybe someone dives into a pool, it's too shallow, they hit their head, they break their neck, spinal cord is severed, they're immediately paralyzed. That didn't happen to Mr. Bennett. He felt okay after the accident. He felt bad that night and then had a gradual worsening of his symptoms over several days before he had emergency surgery. And I want to show you just immediately after the wreck, we've got a dash cam video showing Mr. Bennett walking around. That was Mr. Bennett in the vest. That's the officer, obviously. He's walking around, and it extends on. It goes 30, 40 minutes, and there's other clips of him sort of walking around the other side of the trailer, not doing any calisthenics or anything, but he's just walking around. But we wanted to know the answer to that question. Why didn't he have severe symptoms? So we went and took the deposition of the ER doctor, Dr. Chapman up in Charlotte, and he said there's 2 types of spinal cord injury. There's a complete spinal cord injury, where the spinal cord is severed and there's immediate paralysis. That's sort of the pool scenario I was thinking about. And then there's an incomplete spinal cord injury. And that's where the spinal cord is not severed, but it's damaged. Now, Lewis, the evidence will show, suffered an incomplete spinal cord injury. His spinal cord was bruised, but not severed. So when a bruise, he has impact, he has swelling, and he has discoloration. The inflammatory process occurred over several days, and his symptoms tracked that progression. Now, bruises on the spinal cord, as I said, are not like bruises on the skin.
They don't get better. So we asked the doctor about his progression of symptoms that we described before. I didn't show him this, but we described in his deposition that you'll see the progression of his symptoms. I even said, there's a video of him walking around. Doctor said that doesn't change his opinion. The wreck caused it. And we also showed that progression of symptoms or described that progression of symptoms to the second surgeon and to the neurologist, and they also said that doesn't change their opinion. The wreck caused it. So what about the second question? How strong of an impact causes central cord syndrome? And the reason we asked this question was because there ain't much visible damage to Mr. Bennett's truck. I mean, that doesn't look too damaged. Now, we did rehang that bumper, and you can see there is some fluids there underneath. There is some damage to the truck. I believe there was an estimate when he got back to North Carolina for $5,000 to fix it. But it's not heavily damaged. You can sort of see that. So we talked to the doctors about central cord syndrome and how much of an impact is required. And they were good to talk to us. They said that they defined what central cord syndrome was. And they said, and all the doctors say, including the defense doctors say, it's from an unusual head movement. So the head snaps backwards, it extends, and it can be side to side, but it's usually that backward head movement. And they identified certain risk factors for central cord syndrome and said mostly men over the age of 50 who have a narrow spinal cord canal. So that hole that goes down through the vertebrae, if it's very narrow, then there's not much room there. And if there's something that happens, a disc pops out, it can really pop the spinal cord. And does Mr. Bennett have a narrow spinal cord canal? Well, according to his ER records and his MRIs, he certainly does. He has stenosis, moderate to severe spinal cord narrowing. Now, he never knew he had this because you don't get an MRI if you don't have any neck issues, and he never had any neck issues. But he had a narrow spinal cord apparently, and so he was at risk for overextension of backward head movement, and that's what he suffered. So this is not a blunt force trauma case. It wasn't a crushing injury where he slammed into something and broke a bone because of that impact. It's a movement case, the evidence will show. And his neck just torqued too far in one direction, and that's what it's about. So the vehicle damage is not central focus in this case, according to his doctors. Now, a picture is worth 1,000 words, and we sent Mr. Bennett's medical records to a medical illustrator. He created a simulation or an animation of what he thinks, of what the records indicated. And I want to show you that now. So we showed that animation at his deposition to Dr. Chapman, the ER doctor, and he said that was a fair and accurate depiction of what he thinks happened to Mr. Bennett. Then we also showed it to his other surgeon and his neurologist, and they both said they believe that's what happened to Mr. Bennett. And they'll testify as such in this case. Now, the lesion that you saw there has destroyed many of the nerve connections to Mr. Bennett's arms and legs, and that's what causes him to not be able to walk right, to be spastic, and have the tremors that he has. The damage to his spinal cord has also caused Mr. Bennett a condition known as neurogenic bladder. According to his neurologist, he can't control his bladder due to the nerve damage, and he has a catheter now that he has to wear all the time. He can't control when he goes to the bathroom, and he has a bag, and it's attached to his leg, and he has to sort of wear that all the time. Now, there's going to be medical records that show he did have prostate issues before the accident. He had trouble going to the bathroom, for just sort of a thing. It wasn't like he needed a catheter or anything, but he did have some prostate issues. But this is different. This is nerve damage to the bladder as opposed to a prostate issue. So I want to make sure that you understand and can preview that. Now, his condition has not improved since the accident, and it's gotten a lot worse, as his doctors will testify. So I've talked a lot about our case. Let's talk about the defenses, and we know these because of legal documents that the defendant has filed. Their first defense in papers they filed was that their company and the driver are not at fault. They did nothing wrong. So despite all the 911 calls, defendants say that Mr. Evans was not negligent and did nothing wrong in the operation of his vehicle. They also wrote in one of their pretrial filings that they never made any contact with Mr. Bennett, and this is a quote, never made any contact with Mr. Bennett. It did not cause any accident. So, Mr. Bennett says there was some damage on his post-trip inspection, but regardless, the evidence will show that if Mr. Bennett had not moved into the guardrail, that there would have been two tractor trailers tangling on 75 at the start of 4th of July weekend. So Mr. Bennett, the evidence will show, avoided a bigger catastrophe by going over into the guardrail. The defendant also filed court documents arguing that their driver's failure to take and monitor his insulin was an act of God. The evidence will show that this wasn't an act of God because the driver misrepresented his medical status for 20 years. The evidence will show also that the time defendant was working at Transcontinental, he had been prescribed and was wearing a monitor that would monitor his insulin 24/7. And it hooked up to his phone where he could get real-time alerts about the levels of his insulin, and he couldn't turn the alarms off. So he could have 24/7 access to his levels of insulin. And the corporation now, they filed papers saying that they didn't know Mr. Bennett was diabetic or insulin dependent. They said they never saw the monitor attached to his arm. They also said they never saw him bring insulin to work every day. But the evidence will show he brought that bag of insulin to work with him every day. He had to take it 4 times a day. He had to check his insulin. He had to check it every time before he drove. So since he was working 8 or 9 hours a day, he would have had to bring the bag. And they also did post-trip inspections, the owner did, when they brought the truck back, but they say they never saw his insulin bag or anything else. Now, at his deposition, the defendant's CEO said it wasn't his business to ask the driver about medical issues. Their second defense is that Mr. Bennett just was not hurt in the accident. They've hired 3 witnesses in this case, an accident reconstructionist, a biomechanic, and a spine surgeon. Now, these are all out-of-state witnesses. I believe the first 2 are from Colorado, and they're sort of a team. There's an accident reconstructionist and a biomechanic. And they sort of testify together. They work for a company that does a lot, pretty much exclusively legal testimony. And they've been paid a lot. They were paid $30,000 or $40,000, I think, when we did their deposition, and they're going to come here and testify. So it should be a higher total. We'll ask about that. But they get a lot of business from the law firm representing the defendants in this case. They've done 13 or 14 cases together. And they admit they're not qualified to give opinion about causation because they're not doctors. So they can't say the wreck did or did not cause his spinal cord bruise, but they say in their opinions that hitting the guardrail will not cause spinal cord damage to a normal person. Well, based on, in other words, they don't consider Mr. Bennett's stenosis in the situation. He's not a normal person in the sense that he has a normal spine. He has that stenosis. He has a narrow spinal canal, and they didn't factor that into their decision. The evidence will show they based their opinions on a lot of incorrect data, and they made assumptions that were favorable to the defendants in place of scientific analysis. And they also hired a surgeon, a spine surgeon. And this is a man from Dr. Frankel. He's from Illinois. He's never met Mr. Bennett. He never examined him, not like his treating doctors who operated on him and did clinical visits and everything. But he's never met Mr. Bennett. He's never spoken to the doctors. He just looked at their medical records and then came to the opposite conclusion of Lewis's doctors. So he looked at Mr. Bennett's records, and I want to just go over some deposition quotes so you sort of understand his opinions. And he sort of agreed with a lot of what Mr. Bennett's doctor said. He said Mr. Bennett did not have central cord syndrome before the wreck. He said that Mr. Bennett definitely has spinal cord damage. He said very little or even a trivial amount of trauma is required to cause central cord syndrome. He even gave the example that if you have this stenotic condition, the stenosis like Mr. Bennett had, you could lay back in a barber chair and get up and you'd have central cord syndrome. And he said you could do that in a dentist chair too. So he was much more enthusiastic about the issue that it was not really requiring any kind of violent movement, just the wrong kind of movement. But he said Mr. Bennett suffered an injury in the transcontinental wreck, but he suffered another injury at some point between 7-1 and 7-7 that caused the central cord syndrome. So he said that Mr. Bennett suffered an injury. He didn't have it before. He suffered an injury in the wreck, but at some point between 7-1 and 7-7, he suffered another trauma that he doesn't know what it is, and that caused the central cord syndrome. And what he says is that because Mr. Bennett wasn't falling out, because he wasn't paralyzed, that he could not have suffered central cord syndrome. But he walked into the ER, so he was never paralyzed, really. He just had the incomplete spinal cord injury the whole time. So like I said, he hypothesizes that some other trauma occurred, but he does not know what. But he does say that Mr. Chapman, the ER doctor surgery, was medically necessary to decompress the cord. And let me just say that there's going to be no evidence in this case of any other trauma that Mr. Bennett suffered between July 1st and the transcontinental wreck and the time he had surgery. Now, trials are presented one witness at a time, and sometimes you can lose context about things. So I want to go over and preview a couple factual scenarios so that you sort of understand what these are when you're getting these facts thrown at you. Number one is there's some typos on the accident report. This wasn't a normal accident where there's two cars and the police come and investigate and they do an accident report. This TCI driver had been driving an hour, running cars off the road through multiple jurisdictions. So when he was pulled over, there was chaos. There was a lot of people following. The police or the sheriff's office had to call in the state patrol. They did the accident report. And they did not go back to the scene where Mr. Bennett's incident occurred. And so there's mistakes. They're just typos, things like the mile marker, the direction, other things like that, just because of the chaotic situation. They don't change the fundamental reality. I don't know if the defense is going to suggest that because there's mistakes that this accident just didn't take place, but the evidence will not show that. Number two, Mr. Bennett and his employer had a falling out after the wreck. Mr. Bennett wanted to go to the doctor. His boss wanted him to finish his deliveries. Lewis's boss would not send him for medical treatment. Now, when Lewis returned home 2 days after the wreck, he returned the truck and told his boss he was done. He did not want to work there anymore. And except for one text, Mr. Bennett has never contacted his boss again. And he only worked there about 4 or 5 weeks before this incident. Now, the defendant started a dialogue with Mr. Bennett's former boss after the accident. They were transmitting texts. There was money transferred. And while Mr. Bennett was on the operating table getting a surgery, literally, they were negotiating a deal to waive his personal injury claim and in exchange for money. And Mr. Bennett had no idea that was going on. His former boss makes some statements about Lewis. They're sort of throwing shade or, just sort of mudslinging stuff. Mr. Bennett categorically denies what he says, but it's out there. It doesn't change the fundamental reality, but that's sort of the dynamic between the two. Third thing is that I want you to look at this picture of the truck. On the left, that's the picture Mr. Bennett took. Now on the right, there's another picture of a truck. And it looks like the same truck, but it's not. You see, one has a 4 and one has a 6. The one on the left has a 6. And neither truck is really damaged that bad. There's similar property damage. But somehow this picture on the right got into the file of not the truck Mr. Bennett was in. And it turns out no one sort of knew where it came from. But when we took the deposition of Lewis's former boss, he had sent this picture, the one that was in his truck, 2 days after the accident when he was negotiating the property damage. And Mr. Bennett had nothing, he didn't take that picture. He was transferring, in the text that he sent to his former boss, there's no picture of that truck. So his boss sent that picture to the defendants and in exchange for part of the property damage settlement. But somehow this picture got into the file by his boss and it was sent to the defendant's experts and all around. But it really doesn't mean anything, but it's in the file and you should be aware of it. Now closing, this is my last chance to address you. I hope you'll keep an open mind until the end of the case. If there's things that are not clear during the trial, we'll clear those up in the closing argument. The standard by which you'll judge the evidence in this case is called preponderance of the evidence. So you weigh the evidence, and whichever one weighs more, whichever one has greater weight, then that's the side that wins the trial. Okay. The main issue in this case, again, what caused the visible contusion to Lewis Bennett's spinal cord? Mr. Bennett's doctors say it was a truck collision. The defense say he was injured in the truck collision, but must have been injured after that, but they can't say what. And the implication is that Mr. Bennett's lying about something. So that's a question you need to answer, and we look forward to presenting our case to you. Thank you.
All right. I've asked the defense to hold just a minute, so I try to generally take a break about every hour or so, or frankly, when there's a natural moment between events. And so what we're going to do is we're going to take just a quick break. So how this works is I'm going to read you these 1 page of instructions, and by the end of this trial, you're going to be able to read it back to me without even having it. Here we go. Members of the jury, while you are outside of this courtroom, do not talk about this case or investigate it in any way whatsoever. You may only receive information about this case while you are inside the 4 walls of this courtroom and from only 2 sources. First, the evidence that you will receive in the form of testimony and exhibits, and the law that you will receive directly from me. These attorneys and their clients have worked diligently for years to bring this case to you, and if you receive information from any other source, it will be a devastating event that will severely impact this trial. Please, please, please follow these directions. So don't turn your phones on. Just go back. Everybody take a moment to step in the restroom. Stretch your legs. As soon as you're ready to come back out, knock loudly. Clint will let us know, and then we will do openings for the defense. All right. With that said, if you all will head back to the jury room, knock when you are ready. Phillips from here on out, because I have Clint and Fletcher, so Mr. Phillips and Mr. Fletcher.
No, please call him Clint. I just,
Our bailiffs all go by their first names. It's just, we're trying to make them approachable by the jurors. Okay, so, so the jurors are just not, and I just finished the last of the designations. My team are getting those ready to bring out to you all. As well as I decided, since this is our first trial with these new rules, to just, I don't normally do my preliminary charges in written form, but I went ahead and signed them and filed them, but I corrected them after I read them to match what I said. So you'll get those in just a second.
okay.
All right.
Before you go on the written.
Yes.
Did you also catch the typo at the bottom?
No.
Roland
Yes.
B. McGovern?
Well, I didn't retype it from scratch. I mean.
I didn't know. I mean, I heard you filed
Yep.
them, and I'm like, uh-oh.
Angel? Okay. This is why I'm not allowed to type my own orders. That's on the record. All right. Thank you for that. Again, very grateful to y'all. It's really nice to have such excellent attorneys. Y'all make me a better judge. Okay. Plan for ready?
Yes, sir.
All right. Mr. Fletcher, you ready?
Yeah, I am. Yeah.
All right. And again, we'll, Angel will fix the typo and get everything out to you. All right. Clint, if the jury is ready, they may come out. All right, you all may be seated. I meant to say earlier that the bag that you all have, if I don't know who has what blood sugar issue or whatnot, but obviously if you need any sort of snacks or wish to have any, the bag also serves as that. So if you wanted to bring something in or if you want us to get you something, just let us know. So talk to the bailiffs if you need anything. All right, so plaintiff has finished their opening statement, which means defense. And remember, there are two defense. Will you be doing an opening statement as well? Right. So remember, whenever we go to the defense, everybody, we'll be doing two sets with the defense. Will you be giving the opening statement for Transcontinental and Occidental?
Yes, Your Honor.
All right. The floor is yours.
Thank you, Your Honor. First off, good morning. Again, thank you for your service. We will be as brief as possible just to lay out the topics that we are going to cover in this trial. But I think right out of the gate, one of the things we need to address actually goes to credibility. Now, as you heard from the preliminary charges from His Honor, he talked about the jury is to consider the credibility of the witness, how they talk about the facts, why they talk about the facts, or what facts they omit. And that is important. And one of the things that stood out was at the very end of the plaintiff's opening statement about an image of a truck that just happened to fall into the file. We don't know why it's there, or that's their claim, but we know why it's there. And when you look at the photo that I'm going to put up on the screen, you're going to get a sense of what is the testimony we're going to hear. Is it truthful? Is it candid? Does it misrepresent things? And those are all of the thoughts that you are allowed to have in this trial to weigh the evidence, the preponderance of the evidence. You saw this picture, truck 4. It was passed off, just dropped in the file. We don't know why it's there. Well, as part of litigation, before we get to a trial, we take these things called depositions. We get to ask questions of the witnesses. We get to ask questions of the parties. And in 2022, 2 years after the accident, the question was posed to Mr. Bennett. Is this the truck you were driving at the time of the incident? Yes. And these are talking about the pictures. And both 1 and 2 were taken on the scene of the collision. Those two were on the scene. Now, the other picture that is part of this collection of 2 photos is just a picture of a scratch on the side of the door. But it's the truck 4 that we need you to focus upon, because Mr. Bennett admitted that that was the truck he was driving. Didn't fall into the file. He pulled over after the incident, or so he claims, walked around the truck after the incident, or so he claims, takes a picture of the truck. And I'd like you to direct your attention to the bumper. Arguably, this truck that the plaintiff is claiming is not the truck that he was driving at the incident, actually has some damage to the front right bumper, looking as if it's partially pulled off. And you were the person who took these photographs, not an officer. Yes, ma'am, I took the photographs. And as part of any deposition, just like here in court, a witness raises her hand, swears an oath to tell the truth. 2 years after the incident, fresh in the mind, admits that that's the photograph he took. Credibility matters. And it's what you're going to hear from the witnesses, and you got to weigh. Are they telling you what is the truth? Do I believe them? We're going to talk more about that throughout this opening. But this is a spinal cord injury. We've talked about it. We alluded to it in the questions when we were trying to qualify you as a jury. This is not whiplash, where you have a strained muscle in your neck, or a bulging disc, or a pinched nerve, where you're fine after the accident. But the next day, you're like, oh, I can't get out of bed. I'm sore. This is a spinal cord injury. And when this case first came to us, and we started to learn about central cord syndrome as being a spinal cord injury, and how any person who suffers from it would have immediate effects, it took me back to when I was in high school. And I'm not going to tell you when I went to high school, then it's going to age me, and then you're going to judge me how great and youthful looking I am. But in high school, we were watching a football game, and Jay Chapman, one of my buddies, on a play, came over the middle to hit a wide receiver and make a tackle, collided, face down, laying on the grass. No movement, any part of his body. Brought out the backboards. There's a hush over the crowd. The paramedics are tending to him. All of us are doing this. Like, please, Jay, be okay. Goes to the hospital. 2 days later, moving his arms, his legs, sitting up in bed, completely fine. He suffered a bruised spinal cord. The phrase that you're going to hear throughout this trial about damage to the spinal cord, a bruise. But the symptoms were instantaneous. We need your help in this case, because we have a lot of questions as attorneys. How, given what we understand, what we believe is an incident of a person who's suffering a diabetic attack, an emergency attack, was weaving on the roads and weaved in front or next to Mr. Bennett's truck and either caused him to jerk the wheel to avoid it, or hit him, or even forced them into the guardrail. And when you hear this, especially when you compare it with Mr. Bennett's injuries, now you wonder, how could this happen? Or did it happen? And as like all sleuths or investigators who are trying to unravel a mystery, you take the evidence that you get and you piece it together. Now we're here to present the evidence. The witnesses will tell you what they know or what they understand, but it's you all who get to decide what happened. And more importantly, if it did happen, could it cause a spinal cord injury? We talked about truck 4, and this is a photograph that Mr. Bennett testified to taking this picture. But what we find interesting from this picture is compared to the picture in opening that the plaintiffs presented of truck number 6, which they claim that's the truck he was driving, why do we have the different truck? And interestingly, Dan, if you could advance it. Interestingly, a license plate that is different. Go to the next slide, please. Now, Mr. Scholl got up here and talked about accident reports, and somehow they have typos. This is not the time where the officer accidentally says I-75 southbound, but he meant I-75 northbound. This is an instance where you have an officer who fills out the traffic report, has to be detailed so you can identify what vehicles were involved. Next slide. But you have a license plate tag that's completely different. If you go back to 4 again. Back one more. 5, 3, and blurry, but 6, 7 to me. You guys can make your own judgment as to what it says. That's not what's on the accident report. If you could go to Mr. Cavanis. Mr. Bennett's boss, James Cavanis. Plaintiffs alluded to him as the person who nefariously said, no, you got to keep working. Can't go to the hospital. You will hear from Mr. Cavanis, although not live because he lives in North Carolina and we can't force him to come here, but you will see his testimony through a video deposition where he talks about the interaction with Mr. Bennett after the incident, where he hears what happens. But it's when Mr. Bennett, after driving for 2 more days, and finally drops the truck back at Mr. Cavanis's lot, Mr. Cavanis recalls an interesting conversation. Next slide, please. All right, and in this conversation with Mr. Bennett, when he dropped off the truck, was there anything that stuck out from that conversation that you believed was odd? Answer? Yeah, I did that. So I said, what do you mean? He said, you don't know how to do it. You got to go to the junkyard and take a picture of another truck. That's from Mr. Cavanis recalling his conversation with Mr. Bennett after he dropped the truck. Next, please. And then we talked about truck number 6 already. It's interesting, when you listen to the plaintiff's opening statement, Mr. Scholl talked about a collision with a guardrail, a vehicle that was traveling 63 miles per hour, hitting the guardrail. And I forget the actual term he used, but I think it was hard or forcefully. That's truck number 6. Where's the scrape damage in that picture? Does that look like a truck that hit a guardrail? That is for you guys to help us decide. You guys are capable of looking at the picture. You have all been involved in car wrecks, dings, scrapes, backing up into a parking ballard. You've seen what damage that indicates a front impact of someone pulling too far in, hence a gouge, or damage that's related to sideswiping a guardrail. Next slide, please. Now, in addition to the pictures, the accident reports, you're going to hear from witnesses. And part of those witnesses, because we had to figure out what happened, to either corroborate Mr. Bennett or figure out, no, it didn't happen that way. So yes, we do have to retain experts. And because those experts aren't the treating physicians, 99 times out of 100, they aren't going to examine the patient. Our expert didn't. But the one thing that this expert, Bruce Frankel, an esteemed neurosurgeon who's done thousands of spinal cord surgeries and hundreds treated people, hundreds of people with central cord syndrome, he didn't need to really examine Mr. Bennett. He didn't need to go further in the past to look at all the medical records that may exist as to prior injuries before the incident. He had to look at one thing. He had to look at the dash cam video of Mr. Bennett getting in and out of his truck, in and out of his truck 9 times while he was at the scene. Because, as Dr. Frankel will testify, spinal cord injuries are instantaneous. You have immediate symptoms. And the video that plaintiffs showed in their opening was just a snippet. So I'm not going to, for the opening, present all 37, but we're going to present the 9 instances of Mr. Bennett getting out, in and out of his truck. Notice how he gets down. Consider how he climbs into his cab using his arms, pulling up, stepping. And you will hear testimony from Mr. Bennett himself that he was asked by the police to move Mr. Evans' tractor trailer to a parking lot to get it off the road. And here's Mr. Bennett coming back from having moved it. After this incident, you're going to hear testimony from Mr. Bennett that he drove for 2 more days. And originally, the route was supposed to take him from Florida on I-75 up to Wilmington. But after the incident, he drives to Brunswick. Next day, drives to Wilmington. Next day, drops the truck off in High Point, North Carolina at Mr. Cavaniss' lot. Next slide, please. When considering the incident and whether it caused the central cord syndrome, there's a 6-day delay. And it's in that 6-day delay where we have to figure out, did the spinal cord get damaged as a result of the incident, or did something else cause it? We obviously could not travel with Mr. Bennett. We weren't around Mr. Bennett. We have to, if we're going to believe Mr. Bennett, we have to believe he's telling the truth as to what happened during those days, that there was nothing. But there's one thing we are certain about, is what didn't cause the incident, because of the ability to get in and out. And we're not going to be able to present evidence that there was another cause that was, days later. We just know that there were 6 days where something else could have happened. And because plaintiff's attorney, Mr. Scholl, already pointed out that Mr. Bennett's spine was in such a fragile state because of his pre-existing condition, anything could have caused this. We're never going to know what specifically caused it, but we are going to present the evidence that's going to show what did not cause it. Dr. Chapman, you heard about him. He's the ER orthopedist who worked on Mr. Bennett's spine on July 7th. What causes central cord syndrome are the mechanics of the neck extending. You will hear the term extension. That's the neck going backwards. If you hear the term flexion, that's the neck going forward. And Dr. Chapman, the first treating orthopedist of Mr. Bennett, admitted that it's typically, majority of the times, the head extending. And he admits it can happen from non-forceful injuries. And all these doctors have treated individuals who, leaning back into a sofa too far and falling asleep, leaning back into a dentist chair, looking up at an airplane, that movement, if you have that delicate that spinal cord, can cause the discs or bony spurs called osteophytes on the vertebrae poke into your spinal cord. From extension of the head and neck, and I get them to clarify, the extension of the head and neck, that's tilting backwards, correct, it is. Next slide, please. And now Dr. Bendix, the first non-ER treating physician to work on Mr. Bennett's neck. He even in his deposition says the same thing, neck extension causes it. Yes, in all likelihood, in order to have a central cord syndrome, it requires an extension, a movement of extending the neck. And you just demonstrated for the camera your head going backwards, correct? An extension movement, that's extending the neck. So understanding the medical science of how central cord syndrome is caused, you have to have the mechanical or the engineering science behind that. These are the people who study body mechanics, body movements. Now, they can't testify to what specifically Mr. Bennett endured because they're not his treating physician. But they can talk specifically about what the human body does under certain forces. And everybody knows, basic from their high school classes, that physics, bodies tend to go in the motion, stay in motion, bodies react to opposite forces. And so you picture a body in a truck, if they sideswipe the guardrail, what's their body doing? Is it going forward or is it going back? Now, Dr. Stern is going to testify after you hear from her collaborating accident reconstructionist. This is the person who calculates the forces involved. Dr. Stern is going to say, It's a gentle movement forward. Gentle movement forward, gentle movement back. No whiplashing of the neck, no extension of the neck. And she has sat through the human body testing where they've tested these forces, the directions and control. And she's going to say there's no head extension. Now, there was a comment up from the plaintiff's counsel that there was sloshing in the back, that this caused a extra force from the back into the cab. I don't think you're going to hear from their experts that's going to say that that's the mechanics or the forces involved or how much was actually in the load of the truck at the time. What you're only going to hear is really the testimony of Mr. Bennett as he describes it. He could be right, could be wrong. That goes to credibility. And the stuff we talked about on the front end goes to his credibility. So you have to weigh that. The issue here is causation. I'm not going to give you the law on what causation is because that is for the judge. But y'all are intelligent people and you can understand what causation means. Did the incident, first did it occur as Mr. Bennett describes? But even if it did occur as he describes, could it cause central cord syndrome? Because I think at the end of this case, we're going to be asking you that to determine if the incident caused central cord syndrome or a spinal cord injury. We're going to ask you at the very end, if you believe that, to enter a judgment in favor of the defendants and find that the defendants did not cause the central cord syndrome. But you're going to hear some negative stuff about transcontinental carriers. You're going to hear about the regulations or the T's they didn't cross or the I's they didn't dot. That may make you angry. That might make you think negatively. But despite that, could this incident cause central cord syndrome? So we hope at the end of the case, you will find in favor of the defendants and this case ends. Thank you so much for your time, and we look forward to presenting our case.
All right, y'all come up here just real quick. Just logistics. All right, thank you all. I'll go ahead and tell you that I say this across the way, which is having good attorneys, like all the attorneys you see here, makes my job easier. So what we're going to do is Ms. Dabbs, as I said to you all earlier, that Mr. Fletcher is representing Transcontinental and Occidental. Ms. Dabbs here is representing the estate of Mr. Evans. So in each time we go to the defense, we'll go to both. And sometimes I'll get out of my rhythm and they'll have to nudge me. But Ms. Dabbs has the right to do opening statements at this time. You wish to do that.
Thank you.
The floor is yours.
I'm much shorter than Mr. Fletcher. Thank you. I know, I need a podium or a pedestal. All right. Good morning. The best part about going last is there's not much left for me to say, so I promise I won't repeat what Mr. Fletcher's already told you, but I do want to tell you a little bit more about the person who can't be here today, and that's James Jeffrey Evans. So you've heard a bit from the plaintiff about what they believe Jeff Evans didn't do But Mr. Evans isn't here to defend himself, so I want to tell you a little bit about what the evidence is going to show you Mr. Evans did do. Now, Mr. Evans did have diabetes, and he did suffer from diabetic ketoacidosis on the date of this incident. But Mr. Evans did treat with endocrinologists. He did have a confusing and tumultuous treatment with his diabetes. In fact, before treating with Dr. Nobles James, he was misdiagnosed as a type 2 diabetic, so you can imagine his treatment was incorrect. So this is Mr. Evans. Mr. Evans did see a valid medical examiner, and he did report to Dr. Hayden that he had diabetes. And he was medically cleared to operate a commercial vehicle in September of 2019. Now, Mr. Evans wasn't a doctor, he wasn't a medical examiner, and he, just like any other layperson, can't truly appreciate the medical terminology required for his diabetes. But that's the purpose of a medical examiner, to make inquiries and to ask questions about his diabetes, and then to make a determination of whether Mr. Evans was medically fit to operate a commercial vehicle, when she did. And you'll see that Mr. Evans relied on the knowledge and expertise of the medical examiner and of his medical providers in order to be able to do his job and provide for his family, just like any other layperson would. And on the date of the incident, Mr. Evans did have a valid medical certificate to operate a commercial vehicle. Because of this, he did comply with the federal motor carrier safety regulations, and he did have the legal ability to have a commercial driver's license and operate a commercial vehicle. Now, it's undisputed that Mr. Evans had diabetes, and on the date of this incident, he suffered from a medical emergency called diabetic ketoacidosis. This caused Mr. Evans to be confused and disoriented. And in fact, the officer who responded to the incident, after speaking with Mr. Evans, conducting an investigation, noted that it was obvious that he was in a state of diabetic shock and that Mr. Evans was not in his right mind and was in dire need of medical attention. And in fact, the only person that left the scene of this incident in an ambulance was Mr. Evans. You've heard that Mr. Evans had a history of diabetes, but you'll see that there is no evidence that he had suffered any other similar instances while driving a commercial vehicle. This was truly a medical emergency. And because this was truly a medical emergency, there's no evidence that Mr. Evans previously suffered any similar situations while driving a commercial vehicle. The law will tell you that Mr. Evans can't be responsible for this incident. So on behalf of my client, I want to thank you guys for being here. You have the hardest job in the room by far. So we appreciate your attention and participation in this case. Thank you.
All right, so what I spoke with the attorneys about a minute ago is this next witness is going to be the first witness, I believe, is going to be a virtual witness. Is that correct? I also have some housekeeping I need to address with the attorneys outside of your presence. So what we're going to do is I'm going to let y'all go. I'm going to go ahead and do the housekeeping with them. We're going to test the virtual witness, make certain that everything's lined up. And then what we're going to do is have y'all come back like 12:50, somewhere in there, so that we can start promptly at 1. And that'll give them enough time to do the housekeeping that I need, as well as let me test with the witness. So does that work? Does that make sense? Is that what we talked about? Okay, just making certain I wasn't saying something that caught you all off guard. Okay, so here's what we're going to do. I'm going to find my instructions. You know what? I know what they are. All right, so hey, don't go looking anything up about this case while you're outside the four walls of this courtroom. You are not to get information from anywhere other than the witnesses who testify and the exhibits that are placed into the record. The law that I give you and nowhere else. If you get information from any other source at any time, then it will cause a traumatic event that frankly may not be able to fix. It is very important that you not discuss the case. And again, as you come and go, you will see the parties and their attorneys in the courthouse. Just ignore them as they ignore you, and everybody will be following my instructions and nobody is being rude. If you want to leave anything in the jury room over your lunch break, feel free. The bailiffs will lock it up when the last juror leaves, and they will unlock it when the first juror comes back. So everything in there is secure. Coffee pot is back there, so if anybody needs coffee in the afternoon, stay awake. Feel free to get as much coffee as you need to make that work, or bring a drink back that you need that you prefer. With that said, if anybody, again, I know some of you have some employment stuff you were working out. If you need anything from the court on that, just tell the bailiffs and we'll get with you and make certain that your employers are communicated with from the court as to what's going on, so that y'all can be here okay. With that said, if you want to grab anything or leave anything in the jury box, go ahead and do that. Be back here about 12:50. I want to start right at 1 with the virtual witness. And if there's any questions, we can go ahead and address it, because I know that that's how y'all are editing the deposition. So I also thought I'd give you just a little extra time to edit away. I also thought if your witness who could jump in here, I could test that, because we've had this go south. Or did he already cut him loose?
He is like on a family reunion up there, so he was not entirely happy about 1 o'clock. He's like, all right, I got to go do something with people. I will definitely be back on.
Okay, well then I'm gonna trust that when he gets back on, he's gonna be somewhere with good Wi-Fi and a good signal, because that's, so if
He's
you,
been good since I've been talking to him.
okay, perfect.
Yeah,
Anything?
before he gets on, I do want to raise there's some anticipated hearsay, and I wanted to address that with the court beforehand, because if it accidentally comes out, you can't put the toothpaste back in the tube.
Okay, well, y'all are welcome to sit if you'd like, but yes, tell me what's going on.
So Officer Maddox, in my conversation with him, recalls a conversation he thinks he had with the daughter of Mr. Evans immediately after the incident, and recalls this person who he didn't corroborate, but just assumes it was the daughter based upon information he was provided. The daughter says that Mr. Evans has had this type of, and I forget the term he used, but either this episode before. What she meant by that, who knows? Whether it is his daughter or not, it's not only hearsay, it's hearsay within hearsay, because she presumably may have gotten the information secondhand from another person who told her, or her dad told her. So it has no, it'd be highly prejudicial, and there's no way to verify that it could be true.
All right, and is the daughter listed as a witness?
No, the daughter's not a witness.
Okay, well then that solves that issue. I mean, unless y'all have something magical that I'm missing.
No, and he mentioned to me, like I confirmed his availability, he mentioned this conversation with Mr. Fletcher. I asked him if he knew who that person was. He's like, honestly, I have no idea. I'm like, was it Mr. Evans, he was like, no, it was a female. I just don't know who that person was.
Okay.
So it's not a question I anticipate asking.
All right, perfect. And if you'll just instruct him not to go into that.
Yeah.
Even if he thinks the answer is that, don't answer
No,
that.
when I talked to him last night, I told him that that's not something we're asking about. Please stay away from that. If it's not a witness that we can bring in or medical records, it wasn't a doctor at one of the facilities or something like that, and it's not that we can figure out.
Okay.
Yeah.
All right, we got that addressed?
Done in an abundance of caution.
Oh, absolutely. Anything else? Angel, back here says that she's got all the orders ready, so I can go get all those and pass them out and let y'all look at them.
Potentially, plaintiffs and defense are stipulating to the Georgia State Patrol action report coming in and the report from Officer Maddox. There was one line at the end of Officer Maddox's report where he talks about the reason why he did not issue citations in the case. And so our anticipation is to redact that line. We're leaving in the line that says, I can pull it up on the screen if that makes sense.
I've already ruled on
Yeah.
the citation, any reference to citations issued or not is not admissible, so.
Okay, so
So-
we're basically cutting out that last sentence that includes that line in his
That-
explanation.
That is correct, and
But
that
we're
is what
leaving in
you,
the section that says he was sent to the ER suffering from diabetic shock.
Yeah, and, you brought up designations. For purpose of the designation, so we have it on the record and so everybody understands. Scott, if you're the party that's proposing the witness, you will take ownership of the edits of that, factoring in the judge's orders?
Yes.
And then the
I-
ones,
I
and the
was
ones
up
that,
till 10:30 trying to do that last night.
and then the ones that we're proposing to use will take ownership of editing that to factor in the orders from the judge.
Yeah, and the only question I had was about Mr. Cavness and Dr. Nobles James, because we don't have those videos. We were advised by the court reporters that our exhibits, as we display them on the screen, will show on the video.
And I believe the videos are in the exhibit list that was uploaded, or was it just the transcript?
I think it was just the transcript. I didn't see the actual videos in there.
Okay, we can get you the videos.
And I just wanted to confirm that our exhibits are actually showing, that's all. Because otherwise, we just want to try to get our people to show our exhibits at the time where we were referencing them in the depositions.
well, and I have found that a quick beat after opening and before everything starts, for everybody just to go, we're all in agreement, is a useful exercise. So, all right, do y'all need anything else before I go grab the orders? And again, this next minute will just be us just making certain that everybody's looking at everybody and going, I'm good, and then we'll break for lunch as soon as everybody gives me a thumbs up. So I don't have a specific time, I just want us to check the boxes and make sure. Anything else?
No, Your Honor.
All right.
Oh, one other thing, Your Honor, just this, the ruling you made about, I can talk with the defense about it, but we would like to do some research on this whole idea of, they can say that the case will end as long as they don't tie it to a certain phase.
Yes.
I'd like to understand their argument on that so we can look up some law on that. So, I mean, it wouldn't be relevant again, I don't think, to a closing argument, but I'll talk with them about it. and
Okay.
Would like to maybe revisit that if the law is on our side.
Yeah, I mean, again, oh, I see what you're saying. Okay, y'all talk. I don't see
Well-
myself changing that, but y'all talk.
I don't know the case law off the top of my head, but there's case law out there, and as well as the plain language of the statute.
Well, and again, let's just all be very careful. Again, as best I can tell, we're one of the very first cases out in this, and so a little extra communication will go a long way.
Yeah.
So, I mean, again, I had to change my stuff and then, had to change it again. So, all right, well, we're good. Let's go off record. Y'all talk. Let me go get the orders. As soon as everybody gives me a thumbs up, we'll break for lunch. just put on record, we tested off record. Okay. Otherwise, this would be a miserable transcript for you. We've been here. Oops. Yeah, been here, done that. All right, let's see. Mr. Maddox is there. Allow mute. All right. Mr. Maddox, you there?
Yes, yes.
Okay. So we're not officially on record or anything. I'm just turning it on and checking the audio. So far, so good. Can you see? Actually, I need to turn my screen back on. Okay. So will you just tell me a little bit about the weather there? The court reporter is going to check your audio too.
Sure thing. We're currently in Georgia, it's Lake Russell's, partly cloudy.
Yeah, I lost you there. All right. So let's. Can you see us okay now?
Yes, sir.
Okay, so you definitely have a little bit of some jumpiness going on with your testimony. So let's, are you the closest to your Wi-Fi you can get?
Yes, sir, I am.
Okay. Then what we'll say is, I'll just need you to remember to go nice and slow and loud, because every couple of words, you jumped past a word to the next word.
Gotcha.
So let me get you to talk just a little bit more, and let's all just kind of listen and see if we can do it nice and loud and slow.
Okay. Currently in Elberton, Georgia, it is partly cloudy. Sun. There is no rain.
Whew. Okay, that was tough. That didn't work.
Yeah.
I'm showing all of my bars here.
Same on my side as well.
Yeah, I mean, usually when it's on my side, a bunch of stuff over here will turn orange, and it'll tell me that it's on my side. But I've got all green over here. He could call in. Do you have a secondary cell phone you could call in? We could try
Sure
that. Yeah, it's definitely getting worse as we're going. Let me give you the number.
Okay.
Am I breaking up at all?
No, sir. You're loud and clear.
Okay, I think it's on his end. All right, the phone number for you to call is 650
650
479
479
3208 3208.
320. Got it.
So what we're going to do is you're going to call that number on a secondary phone. I'm going to mute this primary and unmute the phone, and we're going to see if that'll fix the audio, because if your video is jumping a little bit, it's not ideal, but it'll work as long as your audio is clear.
Okay. All right. I'm going to call now.
And this is why we do this. I've done this in front of 2 or 3 juries, and I was like, that's it. We're not doing that in front of any more juries.
So, Mr. Jennings?
Yeah. Yeah, been there, done that.
Right.
Audio's not working on his end, so we're going to have him call in.
Your entry is valid or not started yet. Re-enter your.
Okay, you need the meeting number?
Yes, sir.
It's 2319 088 3639. You can hear me fine. His audio is choppy. So that's what's going on.
Re-enter. This meeting requires sign in. Enter your attendance
Jersey.
profile. Followed by pound.
We're just testing audio.
Number.
You'll see us working hard. Okay, I see you there. So I'm going to mute this. I'm going to mute your main one
All right.
and let the other one in. Okay. All right, so it should say, the host wants you to unmute yourself. Press whatever the number is to unmute yourself. There we go.
That better?
Okay, so let's try this again. Tell us a little bit about the weather where you're at.
Okay. Currently it is Elberton, Georgia. It is sunny,
It's better.
partly cloudy, no chance of rain today.
Okay, so the only downside is I lost your video. Give me a second and see if I can put you up as a grid. Okay, that'll work. You got a picture of me next to you. Blah. Sorry, that came out loud, didn't it?
It's a good picture.
So, all right, let's do this. It will work. Let's try to have y'all put some stuff up on the screen for him to see it. Mr. Maddox, what I'm looking for is, can you see what's about to go up on your screen? You need me to push the button. Sorry, they're waiting on me to push a button. I pushed the button. Nope, wrong button.
Oh, I'm sorry.
Uh,
The old Elmo.
the old Elmo. Okay, Mr. Maddox, can you see the color bars? Thank you. I knew they had a name.
Yes, I do.
Okay, well then, the good news is, IT folks, that we don't have to have y'all log in. Your secondary system will work. Okay, let's test y'all, Liz. Perfect. Okay, we're adaptable. That worked. So, okay, Mr. Maddox, you just sit tight. Everybody step to the restroom, and then we'll get started here in just a minute.
Yes, sir.
All right, so let's go back on record. Any housekeeping from the plaintiff before we get started?
No, Your Honor.
All right, any housekeeping from the defense?
No, Your Honor.
Okay. Okay, and again, if anybody at any moment can't see or hear, it doesn't work, especially Terry, let us know. And we've got our virtual witness. I'm going to go ahead and pull him up, make sure his audio is ready to go. All right, so I'm going to pull this down just so that I can see him. All right, are you there, Mr. Maddox?
Yes, sir.
Okay, so you just sit very still and very quiet. Don't move. And I'm going to bring the jury in, and then we'll officially call you from there. Okay?
Yep.
All right. If you will ask the jurors if they're ready, please make certain they know they can bring out their coffee, water, whatever they've got. It's perfectly okay. Iron, yeah.
You could be that dude.
They got it. Vince got it covered. All right, everyone may be seated. You good? Okay. All right. So just to reiterate where we're at, y'all, the plaintiff and both defendants have given you their opening statements, and I'll remind you again that nothing I say, nor is anything the attorneys ever say, evidence. Evidence is the testimony that's given by witnesses under oath and the exhibits that are placed into the record. So as of this moment, the evidence is officially about to open, which means that you're about to begin receiving the testimony and the exhibits will be placed into the record. As I said earlier, the plaintiff will go first because they have the burden. And as you all can see, as y'all saw as we were getting it in, I was getting the audio all sorted out with the virtual witness. So, Mr. Scholl, you may call your first witness.
Your Honor, just prior to calling Mr. Maddox, we were going to move to enter a couple pieces of evidence that plaintiff's exhibit 2, which is the Georgia State Patrol accident report.
All right, any objection?
No, Your Honor.
All right, plaintiff's exhibit 2 is tendered and admitted without objection.
Plaintiff's exhibit 3, which is the report from Houston County Sheriff's Office.
Objection?
No objection, Your Honor.
All right. And as always with Ms. Dabbs, I just assume if you have something to add, you'll add it. Yes, sir. All right, then plaintiff's 3 is tendered and admitted without objection.
Plaintiff's 5, which is a series of 4, I believe, pictures of one of the vehicle, of a truck,
Okay.
TCI truck.
And that's 5?
Yes, that's 5.
Objection?
No objection, Your Honor.
All right, so those will be, that's tendered and admitted without objection. Is that all of them?
One more.
That's fine.
Plaintiff's exhibit 6, one of the things we both referenced in our openings, number 6 red truck.
All right, any objection?
No objection.
All right, plaintiff 6 is tendered and admitted without objection. I'll hold those up here. Members of the jury, what you will see throughout this trial is that the attorneys have digitized everything to make it smoother in its presentation. But when you are deliberating at the end of this case, you'll have these paper copies to use. I'm just letting you know that there's two identical type with different media format that'll be moving around. So if you all, do you all need these for the presentation or are you just going to use the digital?
We're just going to use the digital, Your Honor.
I'll protect these and we'll put them on the exhibit table in just a minute.
And I assume we have permission to publish to the jury?
Yes.
Then the plaintiff would call Daniel Maddox, Your Honor.
All right. And for record purposes, Mr. Maddox is virtual. We spent a good couple minutes working out all the audio and he should be ready. And Mr. Maddox, are you unmuted?
Yes, sir, I am.
Okay. You may swear your witness and begin your question.
Mr. Maddox, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Can you please state your name for the court, please?
Daniel Aaron Maddox.
And Were you subpoenaed to be here, Officer Maddox? Or is it still Officer Maddox? Let me ask you that first.
No, sir, not at this time.
Okay. If by habit I accidentally call you Officer Maddox, is that going to bother you at all?
No, sir, not at all.
Okay. Were you subpoenaed to be here today?
Yes, sir. Yes.
And were you just unable to be here? And if so, why?
Yes, sir. Just due to my lack of presence there and the need for the video, I had a pre-planned family reunion vacation that was booked about 13 months ago before I even had knowledge of the case coming forward.
Well, I appreciate you being here anyway. On July 1st, 2020, how were you employed?
At that time, I was employed by the Houston County Sheriff's Office as a deputy.
And how long did you work in law enforcement?
In total, approximately 11 years.
And when did you leave Houston County Sheriff's Office?
I left in, I believe it was March of 23.
And did you go to another law enforcement agency, or did you just pursue a different field of employment?
I pursued a different field. Currently, I am a medical sales rep as a robotics operator for total knee and hip replacement.
Okay. As part of your duties as a law enforcement officer, did that involve investigating incidents, motor vehicle collisions, things like you saw on July 1st, 2020?
Yes, sir.
And about how many cases have you had to investigate in your career? I know that's not going to be an exact number. Can you give me a high or low, above 100, above 1,000 in those 11 years?
It's well in the thousands.
Okay. And that includes
Over
both.
the course of 11 years, I would say.
Okay. And that includes both motor vehicle accidents and other types of crimes, correct?
Correct. From motor vehicle to domestic violence to common misdemeanors to high aggravated felonies.
And do you remember this incident from July 1st, 2020?
Yes, sir. Yes.
And I previously sent you a copy of the reports that we entered into evidence before you were called as a witness. Did you get a chance to, or did you need to look at those reports to refresh your memory at all?
Yes, sir. I do have a copy of it.
Okay. And you understand if I'm asking you a question, I'm hoping you can answer from your memory or your refreshed memory and not read from the report, correct?
Yes, sir.
Okay. How did you become involved in this July 1st, 2020 incident?
Currently that day I was on patrol, assigned to the 4th district of the patrol area of Houston County, which would be the southwestern quadrant area of the county. It incorporated Interstate 75, Perry, and Elko area.
And what brought? Oh, sorry. Go ahead.
I apologize. And currently, while I was on duty that day, dispatch contacted me to respond to a be on lookout or a bolo for a semi-truck driving erratically on the interstate.
And I'm going to show you what's been entered as Plaintiff's Exhibit 5. And can you scroll through those pictures slowly, please?
That's me. Just a second. Is that working?
You can see that, Officer Maddox?
Yes, sir. Yes.
Okay. And just scroll through those. And you can take that down, please. And Officer Maddox is, we've seen that vehicle. Does that vehicle match the description of the vehicle that the Bolo was placed on?
Yes, it does.
Okay. And what did you observe about that vehicle? Where did you see it? First off, was it on a side road? Was it still on I-75? Where did you find it?
Dispatch had advised that it was traveling northbound whenever they sent the bolo out, coming from the mile marker 127. Knowing the interstate in the area, I knew that I didn't have time to get south and come back north and try to catch up to it. So I staged on mile marker 135 bridge and began to watch traffic to see if I could have it approach me and then intercept that vehicle.
And make sure I understand this. So you got your car on basically the 135 exit, one of the ramps, and watched southbound to see if you could see the vehicle coming towards you?
Yes, I faced my vehicle northbound and just before the northbound on-ramp and was watching the northbound traffic from the bridge.
And what did you observe about that, that transcontinental truck as it approached you?
So it just as dispatch advised, I did notice the white semi truck approaching, and it would be in one lane, and it would just consistently swerve between two lanes, the middle and the inside, and just constantly change lanes without signal. And it was clear indication that was the vehicle that dispatch was advising for the lookout. Excuse me.
Did you observe that same driving and weaving when you actually saw the vehicle?
Yes, that's how I was able to identify it.
Okay. And what did you do at that point?
At that time, I entered the interstate system via the on-ramp and got behind the semi and initiated a traffic stop, or attempted to initiate a traffic stop.
What do you mean?
Using
I'm just a little bit, because he's breaking up. Terry's nodding at me. So you're breaking up just a hair. I think if you'll just slow your speed down just a little bit, I think it'll be just fine.
Yes, sir.
What do you mean?
Where would you like me to?
We'll pick up where we are, I think. I think we're okay at this point. So you indicated that you attempted to initiate a stop. What do you mean by that?
Got behind the semi and initiated my lights without siren to signal the driver to stop.
Did he stop?
He did not.
What did you do next?
At that time, I initiated the siren and called to dispatch that the semi truck was failing to stop and initiating a chase.
Did you have to involve any other of your fellow deputies to make a stop?
Yes, once the chase is initiated, other available deputies that are in the area respond for assistance.
Did you also call for assistance from Georgia State Patrol?
Don't recall at that time, no.
So not, okay, that might have been later on in the process that they were called out?
Yes, sir. Yeah.
Okay. And were you and the other deputies able to get the truck to pull over?
Yes, sir. I was able to get up to the left far side of the semi truck and make eye contact with the driver and flag him to, it was an attempt to make sure he knew that he was being stopped because the vehicle speeds were still very low, approximately 48 to 50 miles an hour. He was not exhibiting signs of someone fleeing, but he may have just not known that I was behind. So I pulled up to the left side and began to flag, and he acknowledged that I was there, but still failed to stop.
Was there any particular maneuver you had to engage in to get him to stop?
Yes. So once he made eye contact with me, I fell back behind my truck, and he then exited the interstate at Sam Nunn Boulevard in Perry and took a right turn off the exit ramp, which immediately was met with a traffic signal, which Perry Police Department was already aware of the chase happening and were staged in the area. That traffic signal was red, and I guess he acknowledged the red light and came to a stop, and Perry Police Department was able to and pull in front of the semi truck and walk out of the intersection and keep him stationary. Once I noticed that, I come around the semi truck and place my vehicle in front of the semi truck as well to keep him from moving.
And can you say that last phrase again? I couldn't make that out. Keep him from moving. Is that what you said?
Yes, sir. To keep him from continuing on.
Okay. And so he pulled off the interstate. Did he pull into the right lane, giving you the impression that he was going to stop for you? Or what lane did he pull into?
He stopped in the travel lane.
One of the straight through traffic lanes.
Correct. To continue straight as if he was going to continue into downtown Perry.
Okay. And when you got his vehicle stopped, what did you do next?
I immediately went to the driver's door to secure the driver and initiated a felony stop, and ordered him out of the vehicle. He didn't acknowledge. I noticed that the truck door was unlocked, so I opened the truck door and ordered him out of the vehicle. He then acknowledged and got out of the vehicle, and he was then placed in handcuffs.
And you read a Miranda there as well?
Yes, sir, I did.
Okay. And he agreed to speak with you?
Yes, sir, he did.
And what kind of investigation did you engage in at that point? Like, what did you do?
From there, just giving the signs that he was exhibiting signs of intoxication. He smelled very sweet, disoriented, kind of confused. It seemed like he was intoxicated at first. I believed him to be DUI, but wanted to confirm that that's what my suspicions were true. So I began asking several questions if he was currently under the influence of alcohol, if he was under the influence of any kind of drug, did he take prescription medication, was he a diabetic, so on and so forth. To all which he replied no. And so at that time, I went back to his truck and searched his immediate, what we call the lunge area, which would be the area of his driver's seat that is within his reach. On that search, I was able to locate a open bag of prescription medications that had hypodermic needles and had insulin and a glucose meter and a large amount of diabetic supplies. At that time, I confirmed that if the subject was actually not DUI under the influence of any kind of drug or alcohol, but was in fact probably having a diabetic shock.
So what did you do at that point?
I collected the medication. I took it back to him and asked him again if he was diabetic and showed him the medication that I'd found. And he said, "Oh, yes, I am diabetic." And I said, "Okay, well, I need you to check your blood sugar," and asked him if he was capable of doing it himself. He stated yes. So I moved his handcuffs from the back to the front where he could check his blood sugar. He used his own meter and pricked his own finger and was able to check his own blood sugar. And his blood sugar meter, his glucose meter, it just read high. And I, having previous knowledge of diabetes, backstory, my father was a diabetic and also a truck driver. And actually he was retired because he put on insulin. So I was very familiar with the diabetic.
Can you back it up about 10 seconds there?
Say that again.
Can you back up about 10 seconds in what you were just saying? We lost you for a second.
Yeah, so I had him check his own blood sugar with his own meter, and that meter just read high. And having previous knowledge of diabetes, my father was a diabetic and also a truck driver who was medically retired because he became insulin dependent. So knowing that previously from my own personal experience, I knew that his glucose meter was above, his glucose meter only went to 500. Civilian glucose meters generally only go to 500, but when it reads just high, then I know it's over 500.
Did
At
you
that time,
observe? Sorry, oh, 1 second, 1 second. Did you observe any other like? Are you familiar with like the armband monitors that some diabetic patients have to constantly monitor their glucose?
yes, yes, he was not wearing any one of those. It was clear that he used hypodermic needles for subcutaneous injections.
Okay. And you were gonna say what you did next. I apologize for interrupting you there.
Yes. So once I found that his blood sugar was definitely over 500, but just still did not know what it was, I called for EMS response. That way they could check with their meter and get him medical attention. Once they arrived.
So when he goes to EMS, were they able to evaluate him?
Yes. He was removed from handcuff to let them evaluate him. And when they checked it, I believe it was in the 550s.
Were you present when they were checking into his condition?
Yes, sir.
Okay. And did he make any statements to them about his diabetic status?
Yes, prior to them checking his blood sugar, they asked him again if he was a diabetic, and he stated to the EMTs, no, he was not.
Did he say anything about whether or not he was taking his insulin?
Yeah, he said he was not diabetic, and he wasn't taking the insulin.
Okay. And what were the results you observed at the EMS testing?
So once EMS tested, their meter does go above 500, and they found that it was in the 550s. I'm correct, I think it was 550s, if I'm not mistaken.
Okay. And at that point, what did you do with him? Like, did you release him to EMS?
Yeah, with that knowledge, it was known that he was in a state of a medical emergency, and the EMS advised that they needed to take him to the hospital. So he was removed from handcuffs, and due to the fact him being in diabetic shock, any citations for failure to yield and whatnot were not issued.
All right. Mr. Maddox, listen closely to the question and answer the question that's asked, okay?
And Your Honor, we moved to strike that last statement. I mean,
any objection?
I think he was responding to the question as best he understood it.
Okay, it stays where it is.
okay. Well, the question was, did you get released to the emergency personnel, not anything about charges?
Yeah,
So-
so you're correct in that I stopped the witness.
I appreciate it,
Let me put
Your
this on
Honor.
record. You're correct in that I stopped the witness. I'm not striking it, and
Okay.
we can keep moving.
Thank you, Your Honor. After he was released to EMS, what did you do with his truck?
So at that time, I'm sorry, before he left the scene there, I did ask him if he would give authorization for somebody else to move his motor vehicle, his semi. And once he said yes. Once he said yes, there was another 18-wheeler driver there. And I asked if he would move that motor vehicle out of the roadway and into the parking lot, which I think it was a boat center that was there at the corner that had room to park the motor vehicles. We just moved it into that parking lot.
Okay. And did you get that permission from him or from somebody at the company?
I had asked him initially, but given the fact of his state with medical emergency, I went ahead and did contact the company as well, and they authorized it as well.
Okay. And you indicated, we talked a little bit about Georgia State Patrol earlier. Now, Georgia State Patrol was also on the scene. Is that accurate?
Say that again.
Georgia State Patrol was also on the scene?
Yes, they were.
Why did they?
So they got called out because the other 18-wheeler driver that moved the truck advised that he had been run off the road. And we generally, with Houston County Sheriff's Office, we work several accidents throughout the county. We do utilize state patrol to work traffic crashes on the interstate. So we contacted them to work any traffic accident that may have occurred on the interstate that we were unaware of.
Okay, so is it fair to say that in this case, your focus was on investigating the situation with Mr. Evans and not with investigating an accident or whether an accident took place or where the accident took place?
Correct.
Okay. And can you pull up Plaintiff's Exhibit 6, please? And that's does that appear to be a picture from the scene of Mr. Bennett's vehicle?
Yes, sir.
Okay. You didn't do any inspections of that vehicle or anything like that to determine what was wrong with it or anything like that, correct?
No, sir, I did not.
Okay. You can pull that down. What did you do with the diabetic supplies that you found in the transcontinental truck?
They were turned over to EMS to be transported to the hospital with him.
Did you have any further contact with that driver after he left to go to the hospital?
I did not.
Now, with regard to the accident investigation, you said you turned that aspect of the incident over to Georgia State Patrol?
Yes, sir, I did.
Okay, and you've reviewed the Georgia State Patrol report. Is that fair?
Yes, sir, I have.
And in that report, it indicates something at mile marker 134, but your report says mile marker 127.
It does.
Do you have any explanation for that difference?
Well, reading his report, I believe that it was a typing error because you can read through his report and you can see several other typing errors. I believe that was just made an error.
Okay. And according to your knowledge, dispatch indicated you that the incident started at mile marker 127?
Correct.
Or thereabouts?
And yes, and to also note, generally, 127, that's really close to our county line coming from Cordele. So that's generally where we would normally take the city line.
Okay, so if something happened south of 127, your 911 wouldn't pick that up until 127?
Correct.
Okay. Is there anything in that Georgia State Patrol report that you can see that indicates the police went back to any previous mile marker to investigate damage to a guardrail?
Not that I'm aware of.
Okay. And you, I'm assuming from your testimony, did you go back to any of those previous sections of I-75 to look for evidence of a crash or anything like that?
No, sir, I did not. That information was turned over to GSP.
Okay. Do you remember speaking with Mr. Ogletree from Transcontinental about, I believe you said about moving the truck?
Yes. Yeah.
Okay. Is there anything else that, Mr. Ogletree said to you that is pertinent to this case that we need to be aware of?
Not that I can recall. I do remember speaking with him and advising that he was a heavy diabetic and insulin dependent and really had no business having a CD bill.
Okay. One second, Your Honor, might be done. Sure. Thank you, Officer Maddox. Defense is going to cross-examine you now, I believe.
All right. Mr. Fletcher, you may go first.
Yes, Your Honor.
Officer Maddox, can you hear me all right?
Yes, sir. Yes.
All right, Officer Maddox, my name is Clinton Fletcher. I'm one of the attorneys for the defendants, Transcontinental and Occidental. Thank you for taking time out of your day. You obviously, in investigating traffic accidents, are very familiar with the forms that are called the Georgia Motor Vehicle Crash Report. Is that correct?
Yes, sir. Yes.
All right. Because it's already been tendered in, I'll ask that Plaintiff's Exhibit 2 be pulled up. Bear with us here, Mr. Maddox.
Yes, sir.
Are you able to see what's up on your screen, Mr. Maddox?
Yes, sir. I can see that it's a crash report, but it's quite small. Oh, there we go.
There you go. And this
Yes.
This crash report is the typical form that officers responding to an accident fill out. That's correct?
Yes, sir. That's the state form.
Okay. And in terms of these traffic accident reports, in your experience investigating an accident, you obviously inspect the scene, right?
Yeah, yes, sir. Yeah.
All right. And you take down information of the vehicles that are involved, right?
Yes, sir.
That was a yes, sir?
Yes, sir. Yes.
Yeah. And in terms of taking down the information of these vehicles, in your experience, you write down the tag number of the vehicles involved, right?
Correct.
All right. And in terms of the tags for tractors, motor carriers, large trucks, those tag numbers are on the front of the vehicle. Is that correct?
Sometimes, yeah. Most of the time, yes, it's on the front. Sometimes it still can be on the rear. And it depends on where the semi is from. If it's from the state of Georgia or another state or so on and so forth.
But if it's on the front of the tractor, you would report it on this accident, motor vehicle crash report, right?
If I was the one writing the report, correct, yeah.
Sure. And you didn't draft this report, though, correct?
No, sir, I did not.
Great. Now, if you wouldn't mind turning to page 2. Second page, please. And if you could expand so that bottom block down there, yes. Now you can still see your screen, correct?
Yes, sir. Yes.
Now, on this screen, there's a portion called occupant information. Do you see that?
Yes, sir.
All right. And correct me if I'm wrong, this is a portion that you fill out regarding the actual occupants in the vehicles that are involved, right?
Yes, sir.
All right. And in this, I'll represent to you, this is the accident report related to the incident that we are here discussing. It lists the names of James Evans as one of the drivers, right?
Yes, it does.
It also names the other driver, Lewis Bennett.
It does.
All right. And going across the top of occupant 1 under James Evans, it obviously listed that James Evans was driving Unit 1 as it was identified, right?
Identified as vehicle 1.
Yeah. And my understanding of these reports, when it says position 1, that means they're in the driver's seat, right?
Let's see. Let me double check. Yes.
Yeah. And then the safety equipment, that would be indicative of someone when number 3 wearing a seatbelt.
Correct.
All right. And then where it says ejected, a number 1 would indicate that they were not ejected from the vehicle, right?
Correct.
Okay. And as I'm understanding, Mr. Evans didn't need to be extricated by the jaws of life. That's what number 2 means, right?
Correct.
And number 2, airbag in your codes, as you understand, that means the airbag didn't deploy, right?
Correct.
All right. And then here under injury, number 4 indicates that it's an injury that needs medical assistance, right?
Correct.
All right. And then taken for treatment, number 1 means that they were taken away in an ambulance, right?
Correct.
And as you testified earlier, you had Mr. Evans taken away in an ambulance.
Mm-hmm. That's correct.
All right. And now skipping down to Mr. Bennett. Obviously, the jury can see what the position and safety equipment and ejected number 1, but there's a 0 listed under injury. A 0 for injury means there was no injury, according to this report, correct?
Correct. No reported injury.
Yep, no reported injury. And we'll talk about that further. And then number 2, taken for treatment, that means they were not taken away, or Mr. Bennett was not taken away for treatment.
Correct.
Now, while you were at this, when you pulled over Mr. Evans, you eventually got him to stop his vehicle as you testified, right?
Yes, sir.
All right. And when you finally got to his cab, you climbed up to the cab, right?
Correct. Well, I didn't. The cab was short enough where I didn't have to climb up. No.
Okay. Well, you were able to open the door, right?
Correct.
All right. And when you opened the door, I think you testified that you saw him that he was sweating profusely.
I noted that he was sweating profusely once I removed him or ordered him out of the vehicle.
Yeah. And then he had a sweet odor about him, a sweet smelling odor about him.
Yes.
Yeah. And that to you, after you ruled out that he was not intoxicated, that indicated to you that he might be suffering a diabetic attack.
Correct.
All right. And then prior to when you pulled him over, you had seen him weaving all over I-75 northbound, right?
Yeah.
I mean, he was going across all lanes of traffic, right?
I observed him swerving between 2. It was reported as a lookout swerving all over.
And that's what you heard from dispatch or various other officers, right?
Correct.
All right. And if I understood, because you and I actually spoke about this well before, but I recalled you telling me that you actually had heard that he was at one time going southbound I-75. Is that what you recall hearing from dispatch?
Yes. He was traveling south, north, and kind of getting off the interstate and getting back on, not really going a certain destination.
So he was driving with a little bit of confusion. Would that be a safe way to describe it?
Objection, Your Honor.
Absolutely.
Hold on. What's your objection?
He's asking him to make a conclusion about his state of mind. He's speculating on what Mr. Evans was feeling at that point.
Okay, that's overruled. You can continue. Answer the question.
Did you understand the question, Mr. Maddox?
Could you ask that again? I'm sorry.
Yeah, and based upon watching him weave and your experience with him and him going up and down I-75 northbound and southbound, you came to a conclusion that you believed he was confused or he was suffering from confusion.
Yes, due to his diabetes.
Yeah. Now, moving back to where the vehicles were actually pulled over, you got Mr. Evans to pull over and you got him into handcuffs, right?
Yes.
And then you had him take his glucose measurements with his own machine.
Yes.
All right. And then he complied with your requests to take his blood sugar level, right?
Yes.
Okay. And then after you confirmed that he had that he was having a diabetes attack, then you helped him into the ambulance for the EMS to treat him, right?
Well, EMS come and got him from my patrol vehicle. I'm not the one that physically helped him, though.
Okay. And then after Mr. Evans was whisked away by the ambulance, you were then able to have an interaction with who we believe, or that you said was Mr. Bennett, the driver of the other truck.
Yes.
All right. And during those interactions with Mr. Bennett, you asked him whether he had any injuries. Did you not?
Not specifically saying it that way. I asked if he was good. He said yes.
And then with respect to asking him, did you ask him if his vehicle collided with anything?
I did. He said I asked if his vehicle collided with that semi. He said there was no vehicle-to-vehicle contact.
Okay. There was no vehicle contact.
And then that was the only conversation regarding any type of collision that Mr. Bennett had with you.
With me, yes.
Okay. He did not tell you that he had collided with the guardrail during your conversation with him, did he?
Not that I was aware of.
Okay. If we could pull up Plaintiff's Exhibit 6. Can you see your screen, Mr. Maddox?
Yes, sir, I can see it.
Okay. You see an image of a tractor with number 6 on the hood?
Yes, sir. Yes.
Okay. I'll represent to you that this is a photograph taken of the scene where you had Mr. Bennett and Mr. Evans stopped. And you're familiar with this vehicle as you just testified earlier, right?
Yes, sir. Yes.
Okay. And you testified that this was the vehicle that Mr. Bennett was driving, right?
To my knowledge.
All right. And then you said in passing you didn't really perform thorough inspections, but you did happen to walk around the vehicles, right?
I didn't walk all the way around the red truck here with the 6 on it because of how it's positioned out there on the scene. I knew that he had arrived in that vehicle, but it was off to the side and away from where we had Mr. Evans' truck stop.
Yeah, but in terms of you walking around Mr. Bennett's red tractor here, you didn't see any damage to the truck that you attributed to any sort of incident on the roadway between Mr. Bennett or Mr. Evans, right?
Not that I saw, not from where I could see. I also did not inspect the vehicle either.
Give me a moment, Your Honor. Mr. Maddox, thank you so much for your time. I have no
Yes, sir.
further questions.
All right, give me just a second, Mr. Maddox. Ms. Dabbs? All right, thank you very much. Any redirect? Very briefly. All right, Mr. Maddox, the plaintiff has a few more questions for you.
Just very briefly, Officer Maddox. Sorry, Mr. Maddox.
Yes.
Can we pull up Plaintiff's Exhibit 3 again, please? I believe it's page 6. And Officer Maddox, you were not the only officer investigating that scene, were you?
No, sir, I was not.
And the report that we've placed in evidence here, can you zoom in on that second paragraph? You relied on other officers on scene to conduct an investigation of this incident as well, correct?
Yes, sir, I did.
And did those officers inspect the vehicles and talk to the witnesses where you may not have?
Yes, Deputy Crowder and Deputy Ferris also took witness statements and was working that portion of the scene while I was handling the Mr. Evans truck.
And as part of the investigation, was it determined that another semi truck was caused to strike a guardrail as part of that investigation?
I was not told that directly, but I believe that was the outcome.
Is that included in your report? That's in evidence in that zoomed in section there.
Oh yes. Let's see. Okay, so yes, Deputy Crowder did advise me that. I apologize.
No problem at all. Are you aware of any other semi truck related to this incident being reporting having been driven into a guardrail?
Say that again.
Are you aware of any other semi truck being involved in this incident besides Mr. Bennett and Mr. Evans?
No, sir, I was not.
No further questions, Your Honor.
All right, recross.
Thank you, Your Honor. If you could put back up that exhibit, please. Mr. Maddox, this obviously was information you put in a report based upon what Detective or Deputy Crowder told you, correct?
Yes, it was information given from my partner on scene.
Okay. And then in terms of Deputy Crowder telling you what was reported in, It says here, swerving on the interstate prior to law enforcement contact. Are you familiar with that phrase, prior to law enforcement contact?
Yes, sir.
Okay. And as I read that sentence doesn't indicate that Deputy Crowder saw any contact with Mr. Bennett's truck and a guardrail. It doesn't say that, does it?
No, Debbie Crowder did. He's not saying that he witnessed it. No.
Okay. And then in terms of this part, while I was working with Mr. Evans, Deputy Jay Crowder was speaking to witnesses. That doesn't indicate what witnesses he was speaking to, does it?
No, it does not. But I do know that he also had them fill out witness statements, which should be attached to my report.
Okay. So if those statements are in your report and those statements saw that if those statements are attached to your report, you would expect that those statements say that they witnessed contact between a truck and a guardrail. Is that what you're telling us?
I don't want to say it, but I mean, I would assume I would. I have not read the witness statement.
Okay. So you believe, based upon this note here that you put from Deputy Crowder, that he was relying upon witnesses who told him that they saw a truck hit a guardrail?
I
Right.
would assume so. Yeah, he's advising that they witnessed a semi-struck guardrail.
All right. And if the witness saw contact between a truck and the guardrail, it would be in their witness statement, right?
Yeah, I would assume so.
Okay. No further questions. Thank you, Mr. Maddox.
Ms. Tabbs? All right. All right. I'm going to release this witness. Anything else from this witness?
No, Your Honor.
All right. Anything else?
No, Your Honor.
Mr. Maddox, you may disconnect from the virtual system. You've completed your testimony and you're released.
Thank you, sir.
Thank you. All right. You may call your next. How long do you think your next witness is going to take? Ballpark.
I think we're going to play some 911 tapes, Your Honor. That'll be our next. Total, it'll be about, I'm trying to remember how much they were together, probably about 20, 25 minutes for things.
All right. Everybody good to go about 20, 25 more minutes for a break? Okay. They're all nodding. Everybody has the right to pull the emergency brake. Just remember. Okay. Then we're going to do this part and then we'll take our next break.
And Your Honor, for this purpose, for this matter, this plaintiff is moving to enter exhibits 41, 42, and then 123 through 129, which should be 9 total 911 calls.
Those are tracks 1 through 9?
1 through 8, and then the second one of his, yes.
Okay, the one we provided.
Yeah.
All right. So,
No objection, Your Honor.
all right. And that was for 41, 42, and then 123, 124, 125, 126, 127, and
128 and 129.
128, 129.
Yes,
All
sir.
right. Those are tendered and admitted without objection. Those are all 911 recordings.
Yes, Your Honor.
Okay.
And just in case anybody is looking at exhibit lists, we're going to try to go in chronological order, which is 123 through 126, then 41, 127, 42, and then 128, 129.
All right. If I did my part right as the technology, on this side, I'm the technology guy, and on this side, I'm the judge. So if I did my technology part right, y'all are, okay, Liz, give me a thumbs up. was 123.
Yes. That's right. I believe that's a different call. Sorry, Your Honor. I thought it was that. It's just 124.
Okay. Does that conclude the playing of the recordings?
It does, Your Honor.
All right. Members of the jury, what we're going to do, as I said, is we're going to finish that and then just take a quick break. This is the same type of break we took earlier where we're just taking long enough for everybody to stretch your legs, step to the restroom, get a new cup of coffee, water, whatever. As soon as y'all are ready, we'll resume with the next witness. While you're outside of this courtroom, do not talk about this case with anyone or allow anyone to talk about it with you. Do not turn your phones on and do any research. And do not get any information from anywhere other than the witnesses that testify that are to be placed under oath, the exhibits that are placed in the record, and the law that I give you. These parties and their attorneys have worked diligently for years to get this case to you, and it is very important to us to get this through to the finish. All right, you may step back into the jury room, knock when you're ready to come back out. Housekeeping before we bring the jury back out.
Just with regard to the electronic exhibits, like 911 calls, videos, things like that, we were going to wait till we were done and submit one flash drive with all of those on it.
You've already sent them to me.
Oh, yeah, you do have them.
Yeah, I have everything.
Okay.
So that's
I
why
just-
I've already told Terry the good news. She doesn't have to get anything from y'all after this is
Okay,
over.
I'm used to just waiting till I'm at the end, put them all in one drive.
Y'all are great. Like I said, I've said it several times, having all of y'all here with such great lawyers, it just makes my job so much easier, even when you disagree. So, yeah, so Mr. Fletcher, Mr. Moffett, Mr. Fletcher's doing a great job. Okay.
Your Honor, I just have one thing. We plan on reading some admissions into the record.
Okay.
Under 248821. Would you like me to explain to the jury what the admissions are, or would you like to do it?
You know what? I don't know that I have a contemporaneous admission charge to the jury. Let me do it, but do y'all have language you would prefer?
What are you reading? Yeah, we have it during exhibit.
Yeah, but what's the number?
You're right, we did the full exhibit to them, we didn't give that.
Oh, sorry.
We minimized copy. There you go.
Which number is this?
It's from the second set of admission responses.
No, I
got them on there.
Yeah, we basically removed the ones we're not reading.
20 what?
which numbers?
Those were.
All of them. You're
Yeah,
reading all
no,
of them.
no, the numbers, see, they skip over. There's 4 and 5
Ah.
and 7.
Okay.
But you're talking about each one of them, or you're talking about one or two of them?
I'm going to read all the ones that are on.
Okay.
Just trying to
Like
find
this document was originally like 200.
Yeah, this is about 5% of what was on there, because it goes to.
Okay, so this is just, you,
This is just what we're reading.
okay, but you shortened this.
Yeah,
Yes.
yeah, we just included the ones that weren't relevant to what we're trying to prove.
Okay, well, I was trying to grab a pattern while y'all are looking at that. I was trying to grab a pattern that I could give like I do with the depositions where I say the deposition is such and such. But it just, when the admission section in the pattern says, see burden of proof, which doesn't really talk about admissions, so not helpful. Let's just have you put on the record, Mr. Scholl, what you would say to the jury, and then I'll make a call from there.
Right. What I'd probably say, Your Honor, is that early in the litigation, we sent some requests for the defendant to admit certain facts or certain legal positions. And they responded by admitting some. And when they do that, it dispenses with the need for more investigation or more proof as to what they admit. And we want to read now what we requested from them to admit and what they admit.
Okay. I'm asking a very narrow question, Mr. Fletcher, because obviously y'all moved to withdraw these, and I'm not asking you to waive any of that. Is that language to explain to the jury acceptable as an accurate statement of Georgia law on the admissions?
You put me on the spot here, Your Honor.
Well, I had to think.
Adequately pull it to make sure, but I'm overall generally fine with him saying that these are issues that are not in contention at this time because of the admissions.
Because of the admissions and that they are, I think you said binding, what'd you say a second ago? You said,
I didn't use the word binding, I just said that we requested they admit these, they were admitted, so there was no further need for proof on these matters, and these were admitted by the defendant.
okay.
Just for the record, we obviously aren't waiving our right to challenge the court's order and not allowing us to withdraw the admission.
No, and And I'm trying to be very careful not to even get anywhere near that because I know that's a key issue for y'all's appeals. So, and I look forward to what the Court of Appeals thinks of my decision. All right, then that will be fine. Y'all make me a better judge. At the next trial, I will have an admissions charge ready. Every time I bump into one of these, I add them to my pile. So, okay, that's all of my housekeeping. We've got the defense table worked out. Y'all are good on the plaintiff's side, and we now have 2 bathrooms for the jurors. Thank you to Mr. Patrick Shepard, our solicitor, who's letting our jurors step into his office to use their restroom. Anything else before we bring the jury back out?
Is there any objection to us putting the admissions on?
Just reading them in.
Yeah, just reading them while the jury can read them in.
So basically have them on the screen as we read them.
I'd rather you just read it, not have it on the screen.
Okay, so does the plaintiff wish to have them on the screen?
Yes, Your Honor.
All right, so that is granted, and defendant's objection to both that decision and, of course, the underlying decision that y'all don't want them here in the first place is all reserved so that, again, I very much want that to go to the Court of Appeals. I very much want them to get a review on that. Mr. Fletcher, does that cover what you need to protect yourself in this moment?
I believe so, Your Honor.
Okay, because that is my goal as well. Okay, then, yes, plaintiff may put them up on the screen and may read them.
Thank you.
Because some people are audio and visual learners.
Right.
And get used to the sirens, because this happens about 8 times a day. Okay, if you will ask the jurors if they are ready. And I assume you have another witness to,
There'll be a video next year.
okay, that'd be great. All right, then they may come on out. All right, everybody may be seated. All right, Mr. Sholem, you may call your next witness.
Yes, Your Honor. At this time, we'd like to introduce and read into the record Defendant Transcontinental's responses, or selected responses, to plaintiff's second request for admissions.
All right, give me just a second. I'm going to push that up on the screen here. All right, so subject to the defendant's objections that I've already ruled on, you may continue.
All right, ladies and gentlemen, early in the litigation, we sent requests to the defendants to admit certain facts or legal positions, and with the intent that if they admitted those facts, then if they were conceded, we wouldn't have to do further investigation on those facts. And the defendant admitted certain facts and certain legal positions in response to our request that they admit those facts, and these are not in contention. So I want to read these into the record so you're aware of those, please. All right, and they're up on the screen, so you can read along. For number 4, and I'll just read the caption here. Defendants, Transcontinental Carriers' responses to plaintiff's second request for admissions come now. Transcontinental Carriers Incorporated, a named defendant in the above style action, and responds to plaintiff's second request for admissions as follows. Request: please admit that defendant James J. Evans was an employee as defined by FMCSR 390.5 and Georgia Comp R and Reg 515-16-401 of defendant Transcontinental Carriers on July 1st, 2020, at the time of the incident, which forms the basis of this litigation. Response: admitted. Please admit that on July 1st, 2020, defendant James Evans failed to maintain his lane of travel at the time of the incident, which forms the basis of this litigation. Response: the defendant admits that defendant Evans did not maintain his lane of travel at the time of the incident due to a medical emergency. Number 7, please admit that defendant James J. Evans owed duties of due and reasonable care to plaintiff Lewis Bennett. Response: admitted. Number 8, please admit that defendant James J. Evans owed duties of due and reasonable care to all other motorists on the road. Response: admitted. Please admit, number 13, please admit that on July 1st, 2020, defendant James J. Evans failed to maintain a reasonable control of the transcontinental carrier's vehicle while he was operating it at the time of the incident, which forms the basis of this litigation. Response, the defendant admits that defendant Evans suffered a medical emergency and as a result was unable to maintain control of his vehicle at the time of the incident. Number 23, please admit that on July 1st, 2020, defendant James J. Evans was under the dispatch for defendant Transcontinental Carriers Incorporated while operating the Transcontinental Carriers, Inc. vehicle at the time of the incident, which forms the basis of this litigation. Response, admitted. Please admit that on July 1st, 2020, while operating the Transcontinental Carriers vehicle, defendant James J. Evans was operating a commercial vehicle on behalf of defendant Transcontinental Carriers at the time of the incident, which forms the basis of this litigation. Response, admitted. Number 29, please admit that on July 1st, 2020, while operating the Transcontinental Carriers Incorporated vehicle, defendant James J. Evans was a statutory employee of defendant Transcontinental Carriers. Response, admitted. Please admit that on July 1st, 2020, defendant Transcontinental Carriers was an intrastate motor carrier subject to federal and state laws and is responsible for the actions of defendant James J. Evans in regard to the incident described in this complaint. Response, admitted. 43, please admit that on July 1st, 2020, while operating the defendant Transcontinental Carriers Incorporated commercial vehicle, defendant James J. Evans was acting within the scope of employment for defendant Transcontinental Carriers, Inc. Response, admitted. Number 44, please admit that on July 1st, 2020, defendant Transcontinental Carriers Incorporated was responsible for the acts of James J. Evans while defendant James J. Evans was operating the commercial vehicle of Transcontinental Carriers. Response, the defendant admits that it is responsible for any acts of defendant Evans that were performed in the scope of his employment. Number 59, please admit that a licensed motor carrier qualifies a driver to operate the motor carrier's commercial vehicle. Response, admitted. Number 60, please admit that a licensed motor carrier is the only entity which can qualify a driver to operate a motor carrier's commercial vehicle. Response, admitted. Number 68, please admit that the application submitted by defendant James J. Evans to defendant Transcontinental Carriers was not dated. Response, admitted. Number 71, please admit that the application provided by defendant Transcontinental Carriers to defendant James J. Evans did not request a list of all motor vehicle accidents specifying the date and nature of each accident in which the applicant was involved in during the 3 years preceding the date of the application was to be submitted. Response, admitted. Number 73, please admit that the application provided by defendant Transcontinental Carriers to defendant James J. Evans did not request a list of all violations of motor vehicle laws or ordinances of which the applicant was convicted or forfeited bond or collateral during the 3 years preceding the date the application was to be submitted. Response, admitted. Number 75, please admit that the application provided by defendant Transcontinental Carriers to defendant James J. Evans did not request a statement that the applicant had not had any denial, revocation, or suspension of any license, permit, or privilege to operate a motor vehicle that has been issued to the applicant. Response, admitted. Number 95, please admit the defendant Transcontinental Carriers Incorporated did not meet the requirements of FMCSR 391.23. Response, admitted. Number 145, please admit that defendant Transcontinental Carriers did not compile a driver qualification file meeting the requirements of FMCSR 391.51 regarding defendant James J. Evans' qualifications to drive a commercial vehicle prior to hiring him as a commercial driver on behalf of Transcontinental Carriers, Inc. Response, the defendants admit it did not compile a driver qualification file meeting the requirements of FMCSR 391.51 with respect to James J. Evans, but denies that Transcontinental failed to take steps to ensure that James J. Evans was a properly qualified driver. Number 146, please admit that defendant Transcontinental Carriers did not compile a driver qualification file meeting the requirements of FMCSR 391.51 regarding defendant James J. Evans' qualifications to drive a commercial vehicle while retaining him as a commercial driver on behalf of defendant Transcontinental Carriers. Response: the defendant admits it did not compile a driver qualification file meeting the requirements of FMCSR 391.51 with respect to James J. Evans, but denies that Transcontinental Carriers failed to take steps to ensure that James J. Evans was a properly qualified driver. Number 147, please admit that defendant Transcontinental Carriers did not maintain a driver qualification file meeting the requirements of FMCSR 391.51 regarding James J. Evans' qualifications to drive a commercial vehicle while retaining him as a commercial driver on behalf of defendant Transcontinental Carriers. Response: this defendant admits that it did not compile a driver qualification file meeting the requirements of FMCSR 391.51 with respect to James J. Evans, but denies that Transcontinental failed to take steps to ensure that James J. Evans was a properly qualified driver. Number 148, please admit that defendant Transcontinental Carriers did not compile a driver investigation file meeting the requirements of 391.53 regarding James J. Evans' qualifications to drive a commercial vehicle prior to hiring him as a commercial driver on behalf of defendant Transcontinental Carriers Incorporated. Response: admitted. Number 284, please admit that Transcontinental Carriers did not contact Robert A. Hayden regarding the medical certification that defendants James J. Evans prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carriers Incorporated's commercial motor vehicles. Response: admitted. Number 285, please admit that Transcontinental Carriers Incorporated did not obtain the medical examination report form MCSA 5875 for defendant James J. Evans prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carriers, Inc.'s commercial motor vehicles. Response: this defendant admits that it did not obtain the medical examination report form, but this defendant was in possession of defendant Evans' medical examiner certificate prior to hiring him as a commercial driver. Number 289, please admit that Transcontinental Carrier Incorporated did not conduct an investigation into the vision, visual acuity, or visual impairment of defendant James J. Evans as a commercial driver, other than obtaining the medical examiner's certificate. Defendant James J. Evans for prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carrier, Inc.'s commercial motor vehicles. Response: the defendant admits that it did not do any additional investigation into the health or physical fitness of defendant Evans other than obtaining the medical examiner's certificate as required by the FMCSR. Number 291, please admit that Transcontinental Carriers did not conduct an investigation into the diabetic condition of defendant James J. Evans as a commercial driver, other than obtaining the medical examiner's certificate. Defendant James J. Evans for prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carriers, Inc.'s commercial motor vehicles. Response: the defendant admits that it did not do any additional investigation into the health and physical fitness of defendant Evans other than obtaining the medical examiner's certificate as required by the FMCSR. 295, please admit that Transcontinental Carriers did not contact or utilize a third-party provider to contact bulk haulers regarding the medical qualification file of bulk haulers for defendant James J. Evans prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carrier, Inc.'s commercial motor vehicles. Response: admitted. 296, please admit that Transcontinental Carriers Incorporated did not contact nor utilize a third-party provider to obtain the medical qualification file of bulk haulers for defendant James J. Evans prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carrier, Inc.'s commercial motor vehicles. Response: admitted. Number 298, please admit that Transcontinental Carriers, Inc. did not contact nor utilize a third-party provider to contact or obtain any documents from any previous employers of defendant James J. Evans other than bulk haulers regarding defendant James J. Evans as a commercial driver prior to hiring defendant James J. Evans as a commercial driver for Transcontinental Carriers, Inc.'s commercial motor vehicles. Response admitted. And the last page, this 11th day of November 2021, signed by Catherine B. Robinson. That's it, Your Honor.
All right, you can flip the light back. All right, you may call your next witness.
Your Honor, next is going to be deposition testimony video of Dr. Isaacs.
All right, I should still have control of it back there.
Before we get started, there's several records we're going to move to enter that will be referenced throughout the testimony.
All right, I'm ready when you are.
I apologize, Your Honor, I didn't realize I didn't pull them out of the box like I meant to. So the numbers I'll identify for, sorry, CD. Yeah, you want them. And so number 27, plaintiff 27, this will be the records from Irish City Chiropractic.
All right, do you want to read them all out and then?
And then see if I can do that, Your Honor.
Well, yeah, let's do that if that's okay with the defense. Read them all out and then I'll just ask them if they have any exceptions.
Plaintiff's 27, Irish City Chiropractic. Plaintiff's 28, Jones Center for Diabetes. Plaintiff's 29, Kaiser Records for Mr. Defendant Evans. Plaintiff's 30, Perry Hospital Records. And plaintiff's 31, Houston Medical Center Records for Defendant Evans.
All right, any objection to plaintiffs 27 through 31 being admitted?
No, Your Honor.
All right, anything from?
No, Your Honor.
All right, and plaintiffs 27 through 31, which I understand are all medical records, are admitted, tendered and admitted without objection.
Now, there's two other exhibits that we did reference in the deposition as well that are not medical records. Plaintiff's 58, the recommended, actually plaintiff's 57, a list of opinions from Dr. Isaacs. Actually, we're not going to do that. That'll just be on display for them. Plaintiff's 58, recommended test dates, and plaintiff's 59, an A1C chart that was referenced during his deposition.
All right, any objection from the defense?
Do you happen to have it in paper, 57
Yeah.
and 58?
Let me grab those.
I can pull it up on here, but.
Members of the jury, while they're doing that, this part of what we're doing is boring, but very important. It makes certain that everybody knows what's on the table and what's moving through. So just be a little bit patient with us. The parties and their attorneys have worked longer than you can possibly imagine to get all these sorted out and make sure that everybody's seen everything. So the court is very grateful to both sides for all the work they've put into making this moment go very smoothly. Trust me, I've had this moment go totally sideways. So, all right.
No objection, Your Honor, to exhibits, plaintiff's exhibits 58 and 59. And Scott, you may want to put P on there.
Nice.
All right.
That's why I was pulling everything to the side. I apologize for
Oh, sure. All right, so 58 and 59 are tendered and admitted without objection. All right. All right, let me charge them on depositions unless y'all need me to do anything else.
No, sir. That's
All right, so members of the jury, what you're about to hear is a witness that's going to testify by deposition, video for y'all's purposes. A deposition is a witness's sworn statement that is made outside of the courtroom. During a deposition, the witness is placed under oath. They swear to tell the truth. The attorneys for each side get an opportunity to ask questions, and a court reporter is present to record the video and the audio and make a transcript of it. The next video deposition will be Dr. Isaacs for the plaintiff, and it will be presented to you by video, and it'll be up here on your screens that are around you. The video deposition is entitled to the same consideration from you all as if Dr. Isaacs testified here in this seat to my right. And you should judge it in the same way that you would judge any witness testifying here in the courtroom. All right, with that said, you may play the deposition of Dr. Isaacs. Thank you. And Clint DeField. All right, we're going to take a quick break. So this is a good time. We've been at this for about an hour. I think we've got about, how much is left on the?
30 minutes.
About 30 minutes. So yeah, that's a good time for a break. So if you'll flip the lights back on, Clint. And so I'm breaking this up, but I'm trusting that everybody will just follow along as we're doing. But while you're out in the jury room, stretching your legs, and of course, stepping out into the hallway, the solicitor has very kindly allowed us to use the second bathroom. While you're outside this courtroom, do not talk about this case. Do not conduct any investigation whatsoever. Do not turn your phones on. You may only receive information about this case from two sources. Evidence, which is the witness testimony and the exhibits, and the law, which I will give you, and no other source. These attorneys and their parties have worked diligently for years to get this case to you. And if you will violate these rules, it will be a devastating event. So with that said, you may step out into the jury room, obviously get a cup of coffee if you want some. For those of you that want to use the other restroom down the hall, go ahead and do that. Knock when you're ready. All right, thank you very much. Okay, so everybody grab a seat. So just procedurally, just to make certain we're all on the same page. So we're halfway through we finished the direct examination of Dr. Isaacs. Now the defense will do it. Obviously, we're not doing that here. It's up on the deposition. I've already given you those instructions. Then we're good to go. So Clint, if you'll catch that light and we're ready to hit play.